Well, welcome back, everybody. Week 7 of It's Your Estate. Um, my name is Trevor Murphy. I am hosting the series along with Peter Kote is the moderator. And today we have Richard Huntington, who's also moderates some of our series in Laguna Niguel and Mission Viejo when we have our live series going. Richard Huntington, who's a professional fiduciary. And as you may know, we all are professional fiduciaries. And so this particular session, I will be more actively hosting it with some of the topics and things we're going over today. That may be
we're kind of splitting our moderator duties today and presenter duties today.
Yeah, so the topic will be duties. Well, it's going to be duties of the trustee and executor. So we'll be taking a deep dive into the first of all, what the job is. Second of all, what are the codes, the probate codes that govern the job? And then third, kind of after you understand all that, kind of circling back to help you understand who would be the best pick for these positions, because most of you are going to choose family members. And so a lot of the stories and anecdotes you're going to hear today may sound like, scare tactics or something, but that is not the case. Most of the time, everything's going to go smoothly. Everything's going to go fine. We just happen to be in a profession where we get a lot of the situations that are bad. So we think from our perspective, we're in a good, sorry about that, we're in a good position to help you understand the pitfalls. But first, sorry, I put it on silent and then it's still ringing. That's
why don't we do the charitable sponsor for this?
Right. So I'm going to share the screen, and our charitable sponsor today is the WSW Foundation. They had asked us to play a video, but we had technical difficulties getting that up and running. So Pete's just going to speak towards for the foundation.
So the WSW Foundation was started by a gentleman by the name of Andy Eagle, who attended our workshop series. And what he's done is that he's taken this the charitable idea to a whole new level, and he's created his own foundation, which is a 501c3, and he wanted to assist children, elderly, disabled individuals, special needs, and he's combined and made it into an entire family affair. And so that outside individuals can donate to his or their family foundation and actually do good work in the community. So they just recently received a large number of dolls and that type of thing from Walt Disney. They work with all sorts of corporations to make gifts. The Animals for Autism, I Love My Dog, Simple Act of Kindness. So they literally have made their charitable work their mission in life, and they're all about giving money away to good causes. And so thank you, Andy, for being for willing to be a sponsor. And if anyone wants some more information, it's WSW Foundation 501c3. They also will assist. They have a variety of professionals. If individuals want to learn how to do tax-wise giving, they're very involved with the veterans groups as well. So let's move on. And we thank them to make this program possible. By the way, we do not have any for-profit sponsors. We don't have Morgan Stanley. We do not have Bank of America. We don't have any trust companies or insurance companies. And the reason that we don't is because if we take their sponsorship dollars, they want a return on that dollar. And the return on that dollar is to give them your contact information so they can sell stuff to you. All the charities that are sponsors have agreed not to contact you. They'll not solicit you for a donation. They just want to make you aware of their existence. So, and to make this program possible. The wealthier you are, the more things you get in order, the greater the likelihood that there's a possibility for a gift to charity. So that's kind of our mission. Trevor, let's get going on the outline.
Sure. Let me get that up now. Share. And then, sorry, you guys are in the way.
By the way, both my Ask First form and Richard's Ask First form is on our website under materials, and we'll let you read that on your own. We got a lot of issues to cover today, and one of the first ones is that how do you find a professional fiduciary, someone like us? So instead of focusing on what we do, I would like Trevor to go through and show what is a California licensed fiduciary.
Yeah, yeah, I'll get that up. We get a lot of questions, or we get a lot of people asking, you know, what is a professional fiduciary? And let me share. You share, okay. So one of the things is California was the first state. Now I believe Arizona also has a licensing, but we are sort of on the vanguard of the, you know, of the licensing of individuals to serve in the fiduciary positions. And there's some history on that, but it doesn't go back too far. I think 2007, 2008 is when this all sort of was put in motion. And the reason being is, you know, these are very vulnerable people that we serve. And there's also a lot of responsibility, liability that goes along with the job. So Richard, I'm going to hand it over to you. Actually, no,
Sure.
You want me to look up how to find
let's do, that's a great idea, Trevor. Let's do a search and see how someone would find a licensed person here in Orange County. How would they do that if they're on the website? Okay,
so I'm on the website now. Everyone can see. This is from the Bureau of the Professional Fiduciaries Bureau, which holds our licensing. And it's subsumed by the Department of Consumer Affairs. So let's say you were in the market to either name someone in your trust or in your fiduciary positions, or perhaps needing one immediately. You would go to licensees, and we're going to look in Orange County and license verification. And it already came up with the board where we're talking about. I'm going to do an advanced search, which gives it a little more.
But if somebody has a particular individual, they can name the individual by first and last name and look them up as well.
That's true. Yeah. If you're looking up someone specific, you can do that right here. It'd be no problem. But let's say you were just sort of looking in the market. You would need to go to an advanced search here. I'm going to find the board because we are not optometrists. Sorry, it's down. There it is. Licensing Bureau, Professional Fiduciary. Now you can even do it by city, but it's probably more effective to do it by the county you live in. or perhaps the county your mother lives in, if she doesn't live here and you need a fiduciary in another county.
We want to do the active
Yeah,
individuals. There's lots of folks out there that are inactive.
Yeah, you can see that. You can search by lots of things, whether we've been accused of breaching fiduciary duty, whether there's a citation out on us, whether our membership's been canceled, not membership, sorry, our license has been canceled, if we're closed shop, but we want active. And then I think that's enough. We will search. And so this takes you to a page that's been filtered to name all the active professional fiduciaries in Orange County.
And if you look in the left-hand corner, you could see that there's 78 individuals that are active. So how do you tell someone how active they are?
That's a good question. So when they've issued these licenses, they started from the lower ones to the higher ones. Sometimes you may have, like, I'm looking at this now there's only about, I'd say about 1,300, 1,400 licenses that have been issued. I mean, that's not a lot considering the state of California has, I don't know how many people, but quite a lot.
So I did. Yeah, and if they notice that the higher the number, the newer they are.
Yeah, so here's a high number, I think. So you can look up her, kind of gives you her information and all that. And then if you go to fiduciary information for this is public records, by the way. That's why we don't feel bad looking these people up. See, she hasn't had any assets, total client assets. We are required, which Richard will mention on the slide, to report our assets to the Bureau that we have under fiduciary management. That includes real property, that includes brokerage accounts, all that. So she's new, she just started. So she doesn't have any. So you want to look that up just to make sure, because you want someone to be experienced. I can try to find someone who is maybe a little, let's try, we know this particular fiduciary. She's very active in the professional association. So she's in Orange County. Her fiduciary information has, you see the total client assets. So she's reported to the Bureau 23,900.
23 million.
That's what I said, 23 million. To me, it indicates, okay, well, she's active, she's working, she's got clients, she's got a practice. So it's kind of tells you, but honestly, like anything, you can't really tell much unless you pick up the phone or email them and get to know them properly.
Yeah. But we need for you to know that this is available to you. Yeah. It's kind of like if you're going to hire an attorney, check out the Bar Association, to see. If you're going to hire a financial advisor, check out FINRA. Yeah. The same thing for the professional fiduciary.
Yeah, and it's something that I think people need to understand, that there is some recourse for the consumer. If let's say your beneficiary is or you hire a professional fiduciary with the intention, for whatever reason, and then let's say that you pass away and they're in charge of doing your estate for you. Your beneficiaries, if they feel they've been, that we've breached our duties, they could file a report with the Bureau. The Bureau will investigate. So it's not like we're these lone wolves out there with all this control and can do whatever we want. We are definitely governed to a higher standard than, let's say, a family member, and therefore, we have to be very careful with how we handle our practice.
And I think a good thing to understand too is, as fiduciaries, we are submitting our annual report as well. So each year we have to fill out an annual report and speak to any of the clients or trusts that we have closed, any new cases that have been opened during that period. And so the Bureau can track all your cases as you go along. You also have to answer questions whether you've resigned or if you've been removed, if there's any criminal charges or bankruptcy as well.
It's not a perfect system, but it's pretty good.
Yeah.
Let's go to the next slide.
Well, let's talk a little bit about just what you need to do first.
I think that's the slide, isn't it?
No, we didn't. Well, Richard, did you get through all these?
No. Well, so basically there's a prerequisite test and exam that you have to take and pass. We have a, I forget what level.
I believe it's in a slide, all those issues, aren't there, Trevor?
Can't you see the slide?
No, I'm still seeing the website.
Sorry, my bad. There we go. There we go.
There you go.
Sorry about that.
So,
I could
see
it.
we have a criminal background check and fingerprinting. We've got our examination in order to qualify. We have to take classes. Cal State Fullerton offers online classes for this. And then we're also continuing with education as well. So each year we have 15 hours of what they call continuing education, so that we're up to date with the latest probate codes and the latest rules and laws that govern us. And I think the one nice thing to mention too at the very bottom of that slide is the PFAC Association. And it's a nice forum for all the fiduciaries in California to get together once a year. And it's basically educational. So we get all of our continuing education done. But it's nice to be amongst the other fiduciaries and discuss some of their issues. And
they also have a referral system out of that association as well.
Yes.
So,
If you go to the website and you want to learn more about professional fiduciaries, it does a good job of explaining it, probably better than the government one does, just because it's a little better. Pete, want to talk about the services? Now, this could, and also, can you please speak to corporate,
Sure. I just want to kind of back up a little bit because most individuals name family members, and I, like Trevor, we don't want this to be a scare session. 80% of families that go through a death and incapacity and those kinds of things are a family member serves and everything is fine. Even no matter how poorly written the documents are, it's a family, but you have to have documents. You must have documents to have the legal authority. But if everybody gets along, it works out. The problem is that some families don't get along, and some children don't like each other, and sometimes upon a death, that comes out, and sometimes we have to step into those situations. So what we do is that we manage the assets, both financial and real property. Now on the financial side, we're primarily using fee-only fiduciary registered investment advisors for the long term. We act like the CEO, but we don't manage money on the day-to-day basis. Most of the times, if we're involved in distributions, the bank is the source of where we put the money. Real property, on the other hand, has to be managed. Whether lots of times when we step in with real property, it has an immense amount of deferred maintenance, et cetera. So real property is a whole nother thing. And here in Orange County, many individuals have properties, and so that need to be managed. We maintain financial records. Every beneficiary wants to know the dollars that come in and the dollars that go out, no matter if it's a family member or a professional. Trust companies do this. Sometimes attorneys step in to be the fiduciary. Sometimes the CPA steps in to be the fiduciary. So anybody over the age of 18 that does not have a criminal record can be a fiduciary. And we'll talk a little bit about what documents they're going to be a fiduciary of. You have to communicate with the beneficiaries. It's just the number one. If I said there is a criteria for a good fiduciary, it's communication, because everybody thinks the worst of what the fiduciary is doing. You got to understand the tax preparation. Again, it's not that the person has to do the taxes. They have to coordinate the tax preparation. We already talked a little bit about managing real estate, about the sale of real property. Think of real estate. What profession is one of the easiest to get into? And that is to be a real estate agent. I don't know of a person who doesn't know, either in the family or someone outside of their family who is a friend, who's not a real estate agent. Well, we don't hire just any real estate agent. You have to understand that this is one of the biggest assets usually in a person's estates. And we hire special real estate people who understand this, who understand the contracts, who understand what needs to go through there. We also manage funeral arrangements when we are the agent for someone's health care. We oversee the care management. Taking care of other people is almost a full-time job, and we hire care managers and caregivers to do this. So this gives you an idea kind of what to expect from a fiduciary, but most individuals believe that it's about the finances. It's not. It's about understanding your family and the family dynamics, and hopefully with charm, persuasion, communication, it's like herding cats, try to get them all to be on the same page so that a distribution can be made, because the tension, the emotions are high when someone a family member becomes incapacitated or dies. So let's go to the next slide.
Okay, so I'll take this one. So when it says benefits of a professional fiduciary, we're also referring to corporate trust companies as well, because they are the only corporations that are literally a fiduciary. But
we have an article. We have an article listed on our website talking a little bit about corporate trustees. I've been a corporate trustee. I understand a corporate trustee. I would never recommend a corporate trustee unless you have 20 million plus type of estate, and it's in multiple different states or countries. A corporation is a corporation just in the business area. Let me focus a little bit more on this. Is a business, but I consider this more of a family social work than a business. And so one of the things that Trevor said, and Richard also said it as well, you need to meet with the individual that's going to be your fiduciary, because they have to work for you. It's your money, it's your estate, it's not theirs. And so there's a lot of things that happen that are unique to you. And it's not a 8-hour-a-day job. And it's not plugging in, you're not making widgets. So it's depending on your personality, and the fiduciary needs to understand that, and you need to get along with that fiduciary.
Right. So but some of the benefits, and look, we are a neutral third party. We'd have no emotional attachment to the money or the things or the family issues. So a lot of times that can de-escalate some existing family problems. Not our first rodeo. We do this, for our profession. We have multiple cases going on at any given time. So we have a lot of experience in trust administration, which we're going to talk about a lot today. But sometimes when you only do this once in your life or twice in your life, maybe, it's hard to kind of pull, some experience out of that to help you. We have a flexible and vetted network of professionals that we all use, and part of the advantages of being in a group with Peter and Richard or something, or someone, we can call them and say, hey, I need a care manager in North Orange County. Do you know a good one? So we have this network where we can sort of ask each other and so forth. We can also, we can maintain any family advisors, CPAs that you may have had during your lifetime if we feel they are appropriate. Whereas, for example, a trust company will definitely want to pull everything in-house and use their own personnel and so forth. Beneficiaries. So if beneficiaries will get 100% of the benefit with none of the fiduciary liability, and Pete's going to be talking about that a lot today. Well, we all will be, but it's a very important concept that a lot of people really don't understand, how important it is to understand your fiduciary liability and responsibility to the other beneficiaries. So if you have a family member trustee that's also a beneficiary, sometimes it's hard to, which hat are you wearing today? Are you wearing the trustee hat, or are you wearing the beneficiary hat? And so some conflicts of interest can emerge if you're not careful. And what I mean by that is knowing the probate codes that govern your actions and your duties to all beneficiaries. And that's one of the things that we constantly, when we make decisions, when we all our actions, we really are being governed by the codes that we're going to talk about today. One of the advantages of having a private professional fiduciary as opposed to a trust company is we will serve in the incapacity position. So we're going to have a slide reminding us of all the positions just in a minute, but remember the power of attorney and the advanced healthcare directive and living trust actually are incapacity documents. So sometimes it helps with the continuity if you have someone that's your fiduciary while you're still alive, kind of transition and help the family after you pass away. And lastly, your beneficiaries are less likely to fight if you have a professional fiduciary, because we sort of unite the beneficiaries and they all hate us. No, I'm kidding. That's not true.
Actually, because
no, but it does. It takes the heat off one particular family member or beneficiary, and therefore they're not responsible for all the accounting and communications and all the things we're going to talk about today as trustee. So
somebody asked us about the Ask First form. Just so you know, we have the Ask First form on our website, but one of the main things on the Ask First form is how do we charge? What are the fees? So for us as private fiduciaries, I'm going to be generic again. It's usually around 1% per year of the assets under trust. And then if there's extraordinary or what we call setup fees, it depends on the individual professional. That range anywhere from $125 an hour to my rate, since I'm the oldest, $250 an hour. We'll talk a little later on whether or not you should pay a family member to be in the position, or whether you should hire an attorney or CPA to be in the position. But the range of fees are all over the board. Corporate trustees charge between 2% and 4% annually. So that gives you an idea. But all of us have a fee schedule. And so our business name is Professional Fiduciary Services, but in California, we are only licensed as individuals. So you have to name us or anyone else that in whomever you name, except for the corporate, you have to name them as individuals. And so we'll talk a little bit more about how that works in just a little bit.
Yeah, please check the website for the Ask First, and then you can always reach out to get a fee schedule from one of us if you'd like that.
Yeah.
Pete, let's just remind people what the fiduciary positions are for the documents. The thing is that your attorney will not complete your estate plan, no matter what, until you give them these names. And as you can see on the right-hand side, that we recommend 2 to 3 people per document. So that's a lot of names potentially. So Pete,
usually what we recommend is that under the durable power of attorney, because that particular individual will be dealing with money, paying bills or talking to your insurance company or your IRA account, you want someone in that position who has some financial awareness, which is similar to the living trust. So we usually recommend whomever you name as your durable power of attorney, or what we call the attorney in fact, you should name that same person also under the living trust. And then name 2 or 3 people as successors to that individual. Yeah. So that in the event that the individual, because by the way, you're not going to need someone immediately. This is all about the future. And so you don't want to have to change your document every single time someone can't serve or somebody moves or you don't like them any longer, etc. So you want to name 2 or 3 people in each one of these documents.
Richard, a lot of people struggle to decide, so they name co-agents. What do you think about that?
I don't recommend it. I think a good analogy I hear Pete use a lot is having 2 people driving a car. You got 4 hands on the steering wheel and one person wants to turn right and one person wants to turn left. And it makes it tough for decisions. There's a lot of important decisions that have to be made to administer the trust. And, it's a much better scenario to have one person in charge, and then there's also a possibility of a trust protector if that is something that you might want to have, and that trust protector then can oversee the administration of the successor trustee.
Yeah. And most of your real estate will require then both signatures to open up a bank account. Then both individuals need to be there. And there's more than one way to do it correctly. So it's not a good idea to have co-agents, but definitely successors. Same thing for most of your corporates will not serve under your advanced healthcare directive. We serve in all capacities. Many corporates will not serve under the durable power of attorney either. And the reason for that is because it doesn't make business sense for them. It requires a lot of employees' time. And so that's it. And the liability is high. So we serve in all the functions because I think you can't take care of an individual's needs unless you have the legal authority to handle all of the assets and the healthcare.
Yeah. So just so people know, your power of attorney ends at death. Okay. Your healthcare directive ends at death, except with the one duty of the disposition of the remains, burial or cremation or whatever. That is also the agent for the healthcare directive has the legal authority for that. So you want them to be on the same page, at least as a successor trustee or executor. Your will only becomes valid upon your death. And your living trust kind of straddles both. It acts as an incapacity document where your successor trustee can come in during life, and then after you die, your successor trustee will handle the disposition of your financial assets and such. If you do not have an estate plan or any documents, caution, that's why it's in red. You may end up in a conservatorship, which we spoke about earlier in the series, but that is not a legal document, but it's also it's very bad place to be. Okay.
Yeah, I just re-emphasize the whole idea is because most estate planning issues come up at death. That it is just so important to have these documents done in the event of some sort of incapacity. I'm talking Alzheimer's, I'm talking Parkinson's, I'm talking a stroke. You have to have someone there who will step in to help you.
So Pete, can you go over this a little? So you have three levels here. When you're alive and kicking, that means what most of us are right now, I hope. You have a period of incapacity, maybe. And then we all know we're all going to eventually die. So when we're alive and kicking, isn't that like 99% of the time of the trust? What's going on during that time?
Well, you handle everything on your own. If you have a living trust and you're the trustee, the same tax ID number, no one who is listed in your documents should charge you for anything because there's literally no liability as far as they're concerned, and life goes on.
Yeah.
If you now become incapacitated, then what happens is you're still the grantor, you're still the beneficiary, but now you need somebody to manage your stuff. And so whether it's a friend, a trust company, someone needs to step in, pay those bills, make sure you're getting the proper care, make sure your investments are doing properly, making sure your tax returns are filed, etc. And once you're dead, well, by the way, almost everything works out, okay? Because when you're dead, your beneficiaries want your money. And so it might take a little bit longer if you have a dysfunctional family, but it'll eventually work out. And but incapacity, that's the big issue. So on the below there, we go incapacity, determine where you live, pay your bills, make your medical appointments, control the investments, prepare and file your income tax returns, and communicate with the rest of the family your status. So a lot of times family members step in and literally it's a full-time job for them. So, so if somebody's out of state or lives in another county or is a CEO of a company or is busy with their own children, do they have the time to step in and become your advocate is one of the main issues that we see where a professional or somebody who does this on a regular basis will help you out. Let's go to the next slide.
Okay. So I just wanted to make a point that we will be kind of going back and forth, but for the purpose of today's presentation, when we're talking about family members serving as successor trustee, we're kind of talking about the period most of the time when the grantor, the person that created the trust, has passed away and the successor has stepped in. So keep that in mind as we're going through the codes, that's kind of what we're talking about.
Before we get there, one of the questions was whether or not a fee-only fiduciary advisor would be a good person to name as your trustee. And the answer to that is no. It's a conflict of interest for them to also serve as your trustee and also as your financial advisor. And we're going to be talking about make great trust protectors. And we'll talk a little bit more about that later on. I think, Richard, you want to step in and talk about this slide?
Well, he's doing the next one, according to
Okay.
right, or according to
Yeah.
our little chart.
Okay, are you doing this one?
Yeah, I'm doing this one. I don't
Okay.
want to get off things. So, okay, duty to report. We're getting into the code sections now. Remember, we have extracted the probate codes that deal with what we're talking about today. The California probate code it looks like a phone book. I'm sure a lot of you are old enough to remember what a phone book looks like, with just, I mean, legalese everywhere. So if you have trouble sleeping, it's a great thing to read at night. However, these codes, they govern us as professionals, they govern the corporate trust companies, and they govern the family member trustees. They're for everybody. So, and they're statutory by state. So they could be different, they're pretty similar in most states, but in other states, there could be other rules you need to follow. So we're obviously dealing specifically with California here. So this first section is actually a series of code sections which talk about the duty to report information. This statute requires that the trustees keep beneficiaries informed with the matters involving the trust. They actually get quite specific. So what happens is, I'm going to share I know you don't need to read this or know this, but there's a probate section 16061.7. We also call it the 120-day notice. So according to this code, within the first 60 days, it says here, following the occurrence of an event. This could be, usually this means the death of the trustor. It could also mean, if you have an AB trust, that it could be the death of a spouse, and then you're allocating the assets between the survivor's trust and the bypass trust. But 60 days, more or less, to get out a notice where it's a 120-day notice informing. It has to have all the information according to, sorry, let me get this back into, all the information that the beneficiaries of the trust or anybody in the trust, including omitted heirs, if you've done so, any beneficiary, remainder beneficiaries, specific beneficiaries, they will get this notice along with a copy of the trust. And so they will all know what's in the trust, okay? One thing I just want to bring before we move on, most statutes are not very specific, meaning they're kind of flexible to kind of fit a lot of our situations. But this particular one, as you can see, it literally points out that what type of, how big your type font has to be, at least 10 points. And then you have to say this specific quote. You may not bring an action to contest the trust for more than 120 days from the date of this notification by the trustee, served to you upon 60 days, blah, 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 blah. So this 120-day notice, Pete, why do we have this? Like, what's the purpose of this?
Well, there was an attorney in the Laguna Woods area at one time who was putting in, he loved birds. And so he was putting in bird associations, and he was naming himself as the trustee in the estate. And it went all the way to the California Supreme Court, and they made it a rule that every person who is immediate family has to be notified that there is a trust, because the attorney in Laguna Woods hadn't informed relatives who were lived far away and didn't know there was even a trust, and didn't know what happened to their aunt's money or uncle's money. And so every person who's named in the trust and every immediate family has to be notified, and it's very specific how they be notified.
Yeah.
So we as professionals always hire an attorney to draft this notice, because as you can see, it's pretty extensive and it needs to be done correctly.
Yeah. And please note, you cannot waive the, see, there's even, they say you cannot even waive this requirement. Like in the trust, our trust, you know, it's against public policy.
Yeah,
So,
and so it doesn't matter if it's a family member or whether it's a professional, everybody needs to comply who holds the office of a trustee.
yeah. So that's, I'm gonna, let me get back to our presentation. However, so that is just something to be aware of. So that talks a lot about that, but that has to get out to everybody. We'll go to the next one, duty to administer trust, and I'll hand it over to Richard to do what this is referring to.
Yes. So with the trust, as the fiduciary, or for anyone at that matter, the trust kind of becomes your new Bible. So whatever is stated in the trust, whatever language is put in the trust, our duty is to follow that and carry out what that language is saying. So a good example of what we're seeing nowadays, you guys have all learned about the estate tax deduction. Currently this year, it's at 11,700,000. But just back in 2004, 2005, I was only at 1.5 million. And so if you went to see your attorney and you're drafting a trust and the current rate was 1.5 million, a lot of trustors had that much in assets. And so they created what's called the AB trust. With this AB trust, you're capturing both spouses, estate tax deduction, and you have to create two trusts at the death of the first, or at the death of the surviving spouse. So, or death of the first spouse. And so we're seeing that now when it's 11,700,000 for the tax deduction. A lot of people don't need to have an AB trust. And remember, if you do, we'll be happy to take you out for drinks, which would be good. But we see that a lot, and it becomes a lot more of administrative work for us. We have to set up two different trusts. We're going to have two different EIN numbers. We're going to have two tax returns to do. And so we have to follow what that trust says. Another issue we see sometimes is we got Johnny, one of the children, coming to me and saying, Mom really promised me that painting on the wall. She's told the other family members and everyone else that that's mine. And I have to tell Johnny, no, it's not specifically written in the trust. There's no note to that painting specifically. It's going to be treated the same as all the other tangible personal property.
What about, Richard, sometimes parents loan money to children, and Johnny says, hey, Mom said if she dies that I don't have to pay her back. And is that true?
No, well, it has to be specifically stated in the trust. And we see that sometimes that all previous loans and notes are forgiven. If it's not forgiven and we have paperwork that there was a note, then Johnny's on the hook. He needs to either pay it back or we'll reduce it from his inheritance.
So so it's really important for individuals to understand their distribution.
Yeah, I think a lot of this is knowing what your trust says and being current and not procrastinating with making sure, because what happens a lot is people, at the end of life or towards the end of life, the family will, they'll say, we talked about this. We don't want to do it this way. We figured it'd be better if we did it this way. Well, this code says, sorry, whatever it says in black and white is the way we have to administer it. We can't just take these, take your word for it. So that's the importance of this, is keeping, as a trustor, it's your duty to keep your trust up to date. Pete, can you talk a little bit about this code, about the duty of loyalty? Loyalty is it's a word that maybe people get confused as to what you're supposed to be loyal to.
Yeah, the loyalty is that it goes with a conflict of interest, but you have a duty if the person alive, i.e. incapacitated, then your duty of loyalty is strictly to the grantor, trustor person. It's not to his or her children. It's not to the cousins. You have a strict duty just to do what's in the grantor's interest. The other, if someone is deceased, a good example of duty of loyalty would be, let's say you have a car that's desirable in a garage by the beneficiary, who's also your trustee. And that beneficiary trustee wants that car. Well, that duty of loyalty as the trustee hat, he can't just take that car. He has to contact all the other beneficiaries, ask their permission if he can have the car. That's two is, as to the fair market price for that car, all the beneficiaries have to agree to it. In other words, his duty of loyalty extends to the beneficiaries first. His duty to himself is last. So duty of loyalty is huge, especially amongst family members when you name them as one over the other as the trustee.
Yeah. So you have to, it's to all beneficiaries. So really you can think of it as loyalty to the trust document, which has all beneficiaries in mind, rather than to, mom or dad or something. So it's kind of if you're a family member trustee, you really have to be loyal to all beneficiaries and put their interests even before your own, which sometimes is hard to do.
Yeah, let's go to the next slide.
Okay, I'll take this one. So impartiality or impartially having to deal, this is a duty. So if you're the grantor and you're picking your fiduciary, meaning if you're going to pick a child, when I say child, you know what I mean, a grown child, to be your trustee, you have to make sure that they can be impartial. And to be honest, not all family members like each other. Or they may not trust each other, or there could be others. Some grantors make the mistake that, well, they don't really get along now, but I'm sure when I pass away, everybody will get on fine. So I'll name them Co, not to, but what happens is we don't see that happening very often. It's usually the opposite, meaning you were the one keeping them in orbit around you. And then when you pass away, they go to their separate camps. So keep in mind, whoever you choose cannot favor one beneficiary over another, no matter how much of a pain in the butt that beneficiary may be.
That's a legal term?
Yeah, it's in the probate code. But it's a violation. It's a breach of duty if you're like that. And sometimes, especially if you have lots of kids, like 5, 6 kids, sometimes I see these camps, where they pair up and they sort of. So if one of the trustees is in one of the camps, well, that's just a recipe for breaching this particular probate code section. So keep that in mind. It's for the most part. I came onto a case where they wanted somebody because there was 3 kids and they all got along great, but they wanted to make sure that stayed that way because it was set up to be a 1 versus 2 situation if it all went south. Okay, next one is I think, Rich, you're going to take this one for us.
Okay.
Duty to avoid conflicts of interest.
Yes, this is a really big, a big thing. You have to avoid all levels of conflict of interest. You know, so if you've got a family member that's a trustee and he's hiring his college buddy who's a realtor, and there's some kind of a side deal, a kickback or money coming back to the trustee, that's improper. And so you really have to be careful. You need to disclose any just potential conflict of interest. If you know, if you've got someone that you're working with and you have an association with them, if you're married to them or any reason, you need to disclose this information to everybody. As a fiduciary and a trustee, there is no kickbacks. There is no you know, money under the table. Everything needs to be on the up and up, and so you don't get any. You don't want to be involved in any conflicts of interest. And it becomes the best way. You're impartial. You're just getting the job done, and you're administrating the trust accordingly. So you got to really be careful, and especially if it's family members there. They might not know some of the nuances of the different professions, and be susceptible to, you know, taking a kickback or some kind of a, you know,
or even, you know, the car example, Richard, you know, when I've had individuals just go ahead and take the car. I'm the trustee, I'm the oldest, so I get the car. And so that's a conflict of interest. If you have a business, it's a big one as far as conflicts are concerned. I'm going to name myself president of the business. Hey, I'm going to take a salary. That's a conflict of interest. The sale of limited partnership interest. The more complicated your estate is or financial situation is, the likelihood of having conflicts are going to be there.
Yeah.
Conflicts are normal.
Yeah, they're normal, and they're not, I don't want anyone to discourage, because you may have a very competent real estate agent in the family that is also a beneficiary. We're not saying you can't do that, but if you're the trustee, there are ways to protect yourself from what could be down the line problems. So if that's the case, where you're using it, where you're using a beneficiary as, let's say, a real estate agent or a financial advisor or a contractor. A lot of times the son picks up the kitchen before we sell the house or things like that. You want to disclose it first to all the beneficiaries and get their approval before in writing. Yeah. And then if you're, let's say you're getting pushback or you find yourself in a situation where, you know, some people vehemently disagree. Well, there's also the courts. You could use what's called a notice of proposed action to kind of, you know, it does delay things and stall things, and you'll have to pay an attorney to file a petition. But there are methods to protect yourself on these particular issues regarding this particular code.
Yeah. Just the trustee has to be completely transparent. There's no hidden deals. And most that's the problem where family members come in, that they don't communicate if they're going to do the job. How much are they making? What would a separate professional cost?
Yeah,
you have to, that voiding of a conflict of interest is just huge, especially in the family situation.
We're going to talk about family member trustee compensation in the duty to account slide, but that is something that is definitely lots of questions regarding that. Okay, Pete, this is a big one. Okay, this is the duty to take control of and preserve trust property. Now, I want to kind of split this up, because there's real property, meaning real estate and houses. There's tangible personal property, which is all the stuff in the house, right? And then there's financial property, our bank accounts and brokerage accounts that are titled in the trust.
Okay. Well, the first thing is that, let's say, real property. As soon as you die or become incapacitated, one of our duties is to make the property productive, or actually to make all assets productive. We can't just leave assets sit there and not produce some kind of an income. So if you have a child, for example, living in the house with you, and you die, and you don't have any paperwork to state that they can continue living in the house after your death, we have a duty to make that property productive. So we may have to charge rent. We may have to ask the individual to move. Then let's say the individual moves out of the house. Now we have a duty to look at the house and say, what needs to happen? How best do we put this property either on the market? Then there has to be a determination as to what monies do we put into the house to make sure that we get the proper return on that property. And then we have to make sure that we do list the property on the multiple listing service. We can't just go to the neighbor and the neighbor says to us, hey, I could save you real estate fees. I'll just buy your property. Well, the problem there is that you don't know what the fair market price of that property is because you haven't opened it up to the public. So property is absolutely huge issue when it comes to preserving that property. In addition, that in order to sell the property, you need to be listed on the deed. So there's a change of deed. Again, you need legal help doing that.
Yeah.
Personal property, by the way, there's even more issues with property. We can go on this particular topic for at least an hour. So, but let's go to personal property. A lot of times, personal property becomes the major issue, no matter what the size of the estate is. That watch that grandfather owned, I wanted. That painting, the earrings, the diamond ring. Personal property is a lot of times huge. What we recommend is that unless you have an extremely high value personal property, leave the personal properties out of your will or trust. Do a separate memorandum and say, I would like blah, blah, blah to go to these people. Or as you grow older, think of gifting some of your personal properties that are highly valuable. At least you could see the pleasure that they give to another individual. But personal property is huge. And we suggest a memorandum outside. Make your trustee the dictator. If it can't be worked out civilly, the trustee distributes the personal property equally, and you give the legal authority to the trustee to do that. But it has to be stated in your trust that the trustee has that power. Financial. People think that finances are the big issue in a death that occurs. Yes, money is very, very important, but it's usually the family dynamics around the money that's the issue. The good thing about money is it doesn't have moods, doesn't know when to go to sleep, doesn't have to eat, doesn't talk back. It's very easy to handle the money competently and professionally. And there's two ways that this happens. If it's in a trust that goes on to long term, we highly suggest a fee-only fiduciary financial advisor to set up a financial plan for that particular individual. And then we have all sorts of rules around how that money should be invested. For most of us who are deceased and die, and the trustee steps in, we take control of that money, set up a separate account under the trust name, and all the money that's in that estate goes into that separate account. And the reason for that is that money doesn't belong to the trustee. You can't commingle that money with other monies, because everybody who's a beneficiary wants to know every dime that comes in and every dime that goes out.
Yeah,
So
you're bleeding over into other codes.
yeah, that taking control and preserving the asset
Yeah.
is one of the most important duties of a trustee.
I'll add a couple things. One of the things you're going to have to do is get a date of death appraisal. We recommend an appraisal. You can get brokers' opinions and all that, but we recommend an appraisal. This will be your new cost basis, and your fiduciary CPA will need that. When you get your death certificate, Pete had mentioned your attorney can help you file an affidavit of death with the county. That's, you know, the former trustee died, and then there's a new one. Insurance, okay? Preserving trust property, a lot of people don't understand that most of our homeowner insurance, our liability policies, have a cap of like 30 days, sometimes 60 days, as to how long the policies are valid if the house is vacant.
Or if you become the person that has dementia and hasn't paid their insurance.
Yeah.
And all of a sudden the family member steps in as the trustee, and there's a break-in or there's a fire. Guess who's responsible?
The family member. So
the trustee.
Yeah. So just please investigate those. And if you think the house is going to be, you know, remember, we have a 120-day notice. So, you know, that's 4 months in itself. So if you think the house is going to be vacant, you know, I would definitely contact the insurance company and make sure that it's covered.
Yeah, your trustee needs to know that.
Yeah. In regards to, you know, keeping the appearance up, make sure you pay the gardener and everything. And we also change the locks just to make sure no one else has keys. And then, yeah, I mean, in regards to what Pete had mentioned, financial property, obtaining that new EIN number, you're going to have to bring that with all the legal documents to the institution so they can put the assets now in the irrevocable trust under that. Your social security number died with you. Okay, keep that in mind. Okay, so we're going to go see. Okay, I'll answer that now. So next slide. I'll take this. Keeping trust property separate and identified from your own funds. You'd be surprised how common this is, where somebody's been taking care of mom and they've been doing things a certain way because everything's been under mom's trust and so forth. But when she died, like I just said, you know, her social security died with her. Now her trust is irrevocable. So it's a separate entity, and therefore any sort of expense or maybe perhaps income from rental properties need to be kept separate and identified from when she was alive. Okay, because we're going to talk later about how many tax returns you're going to have to file. And if you don't do this properly, then you're really going to have a headache when you try to do that. Okay, so please do not commingle personal funds with the trust funds. Next one, Rich, duty to make trust property productive. Pete talked about this a little bit, but
yeah, absolutely. Yeah. So there you have a duty to make your trust property productive. We see sometimes examples, mom and dad have passed away and one of the children are still living in the house, not paying rent. And there's no language in the trust allowing that child to stay in the house. So we've got an issue. And we, you know, without that language, we either need to have the child removed from the house, or we could seek for permission from the other beneficiaries if they want to allow it while we're getting the house ready to sell. But it becomes a little bit of a hassle. Another example might be a second real estate property, a vacation home, and we have a family member living at that vacation home and not paying rent. So our duty to make the property productive is they've got to pay market rent. We've got to find out what market rent is for that place and that location. And we need to start collecting rent while we're getting things in order to sell the property. It's on the financial side, it's a little bit different. It's, the trustor might have a nice asset allocation. They might be in a 60-40 asset allocation, a lot of exposure in the market. But when the trustor has passed away, we do not have a duty to try and make a killing in the market. Our duty is to conserve the asset and preserve it, and to
Not
make
to
it
grow the
productive.
asset.
Yeah, and so making that productive asset is a very safe interest. So it's just interest from a savings account or a CD. We're not exposing ourselves to any fluctuations in the market at all. So it's we're preserving what's there and not taking any risk is the idea.
Yeah. And so for a long-term trust, these are the rules for
Hey, real quick, when you say long-term trust, can you explain to the attendees what you mean?
A long-term trust would be a subtrust taking care of a special needs child, or a spendthrift trust, someone that can't manage money, or let's say someone dies and the beneficiary is 21 and you're not, and the trust says do not make a distribution until the child reaches 35. So anything over a year, then or a year and a half, you're looking at now prudently investing. And again, when someone dies, it's public record. So you get a lot of calls, or the trustee gets a lot of calls from real estate agents, from brokers, from insurance people, all wanting to be part of managing your money or part of your money. Dying is a huge business.
Yeah.
We don't have a choice. We're all going to die. So it's big dollar business, but in investing it, these are the rules. And by the way, these should be your own rules during lifetime. You should be prudently managing your own money. You should understand your risk and return. You should consider prevailing factors, i.e., how long am I going to live, or how long am I going to be investing? Diversification. We talk about that in the It's Your Money till we're kind of tired of it. Prudently delegate. You can't just hire friends. You've got to hire competent individuals, and you have to monitor.
Yeah.
It's a biggie.
Yeah. In California, if let's say you put the trust money, you're trustee, and you put it with an advisor, and you don't monitor what they're doing, and they're going off on whatever they're doing, and they're not diversified, they haven't done a lot of these things, it's not the advisor that's going to get in trouble. You're going to get in trouble as the trustee, because it's your job to monitor it.
But
so all of these, yeah. So because
these are good ideas for you to have during lifetime.
Yeah, during lifetime, it's great. But if you actually find yourself in a position as trustee of someone else's money in a trust, you actually have a duty, and there's some governance aspects to actually doing these things. Like during our lifetime, yeah, we all want to do these things, and we know we should, but we're not getting in trouble if we don't. But if you are a trustee for someone else, I mean, you'd be surprised how much control and command you have. So that business that your friend was talking about, that's going to be a no-brainer, make a ton of money. the last thing you want to do is put someone else's money to work in that sort of situation.
Let's say you have Enron stock. You worked for Enron, you loved Enron, and you died. And let's say you have 2 children. They said, "Gosh, Dad worked for Enron for a long time. He loved this company. I don't want you to sell that stock." Well, as a trustee, you better sell that stock because you're not diversified, and you got to take advantage of the step up in basis. And unless it specifically states in the trust that you can keep that single asset, you just breached your fiduciary duty. What happened to Enron? It went to 0. And so what's the liability for the trustee? The entire value of that Enron stock in the estate when they held it.
Brutal. Okay.
Yeah. Next slide.
All right. This is a big one, and sorry it's a bit long on the thing, but it's pretty straightforward. Duty to account. It's probably the most breached, I would say. Wouldn't you say, Pete? Yeah.
Yeah.
I mean, there was a comment at the beginning of the series. Someone wrote in saying that it's been 5 years since the trustee has made any accounting to them about all their the trust and estate of their parents or whoever. But the code kind of says at least annually. Okay, so that's if you have a longer term trust that we're talking about. You're at least,
or the estate administration goes on for longer than a year.
Oh yeah, or if it takes longer than a year to distribute everything.
So this doesn't have to be in your trust. This is a probate rule.
Yeah, this is a rule. So the accountings, there are formal accountings that the formal fiduciary accountings that CPAs or attorneys will create for you that have it. If you go to the court accountings, they have it through a specific method. In my practice, I do quarterly accountings with all the trusts that have all the income coming in, all the expenses going out. So all the beneficiaries know every 3 months what's going on. And if they're going to complain, they're going to complain then.
So if you're gonna select a trustee family member, name one of your family members who's somewhat anal.
That means anal retentive for those.
Who will keep records. Everybody wants to know where the money went. Yeah.
And so it's and look, if you're before, like if you were unsuccessful in record keeping is so important in this job. So if you were unsuccessful in keeping trust property separate and identified from other property, if you were unsuccessful in preserving trust property or making it productive, when it gets to the accountings, and I guarantee you'll get to an accounting, all that's going to be difficult, because when you distribute, you're going to want all the beneficiaries to sign off on the accounting. You do not want that kind of out there. A lot of people distribute before they get an accounting, which is very risky, I think.
Well, a family member, if you name a family member, they have to look at this kind of like a business.
Right.
And so, somebody who understands a spreadsheet, so to protect themselves, and they need to follow some of the formalities. They can't just say, "Hey, I love my sister, but I don't love the other one. So, hey, I'm just going to distribute the way I want to. I'm not going to give them any other information." And be surprised how many people do this.
Yeah. No. So look, not all of us are necessarily, this is not our wheelhouse. So it's okay to prudently delegate bookkeeping, bill paying, maybe a daily money manager, property management, things that can help you kind of keep track of everything. Also, please keep in mind, and this is a big deal, the year that the grantor dies, if you're married, let's say the second spouse to die, the surviving spouse dies, the trustee is responsible for filing not only their 1040 and 540 federal and state tax returns, but they're also responsible for filing their 1041 and 541, what we call fiduciary tax returns. So that's already 4 tax returns you're filing. Also, if for some reason, there's an estate, like you have to file an estate tax or something, that's another thing that you have to keep track of. So you could potentially have up to 5, 6 tax returns to file the year the person dies. If your record keeping is poor, this is terrible. This part is the worst. Even for us professionals, when tax season comes on and we got to get it all ready for our CPAs with all of our trusts, it's stressful. And we've been doing this. We do it every year. But so this could really come to bite you if you do not keep good records.
Yeah, this is the duty for the trustee, and it's similar to the executor duty. By the way, these duties are very similar to that. If you just have a will, all of these duties apply to the executor.
Yeah.
But you're reporting to the court. As a trustee, you're reporting to the beneficiaries. And so you could hire a good CPA who understands an accounting. Usually, sometimes attorneys do this. This cost generally runs around $5,000 to $10,000 to do an accounting for an estate. So again, if all the family members sign off, there's no problems. Hey, we're happy. It's okay. It's kind of like when you have a driver's license and you go through a stop sign. Well, nobody saw you, and you're not gonna get a ticket. So, but these rules are there so that a beneficiary can tell the trustee, I don't like what you did, and this is how you broke the law. And so that's the liability. We've got about 8 minutes left?
Yeah, someone was asking about a list of things. Okay, so on your materials page on the website, there is this thing, things to do when a person dies. And it may not have everything, your situation might not have to do all these things, but we strongly recommend you take this list and take it to the trustee that you have, successor trustee that you have chosen, and you go through it and you kind of talk about the things that are pertinent to your situation. We sort of add to it all the time. It's up to 238s, actually 39 different things. So just want to let everyone know that that's there.
Yeah, what I would suggest is that if you name a family member, sit down with the family member, go through the things to do when you die, and go through some of the probate code and talk about, do you get along with your siblings? Can you communicate with them? Let's go to that slide that I think is really important, the one that you just had up.
Standard of care?
No, I wanted to go, the qualities.
Okay. I think Rich was going to do.
Yeah, Richard, why don't you go ahead and do this one? I think this is really important.
Yeah, absolutely. Absolutely. So you want to find the right person with the right skill set to be handling all these administrative duties. When you think of the age of the person, if the trustor is in their 70s or 80s, you want to look for someone that's younger, obviously. You don't want your bridge partner because you guys are all aging together. And do they have the time to do it? So if the family member is, 60 years old and the grandkids are in high school getting ready for college, that son or daughter is going to really be hustling, trying to make some money, and might not have the time that's needed. Proximity is a big one as well. You got family members on the East Coast.
Or even in Northern California, or even in LA compared to Orange County.
Exactly. And Pete mentioned earlier on accountings, you need to be organized. You really got to be able to account for every dime in and every dime out. It's very important. And so that organization is going to show as part of your duties. Ability to delegate, that's another big one. Sometimes coincides with the communication. If you're not able to effectively communicate what jobs and duties you need to have other people do for you.
Yeah, because you're going to be hiring contractors, maybe the gardener, your CPAs, financial advisors, an attorney. If you're not familiar with this, the person needs to get familiar with them.
Yeah, absolutely. And you need to speak their language too. You see a big difference in the language between attorneys versus doctors and nurses at the hospital. So you have to effectively get the information you need and tell them what you want. And also communication is a big thing we mentioned earlier to the beneficiaries, and it's part of that transparency. We need to communicate to the beneficiaries what's been going on, what the plans are. We're being transparent with them, letting everyone know we're not picking favorites. You know, everyone's on the same playing field. And
one of my favorite is on communication is the pillow talk.
Oh, yeah.
You know, the beneficiary's spouse.
Mm-hmm.
Hey, you know, your brother-in-law, he was kind of suspicious, and how long has it been since you heard from him? And nobody thinks the best.
No.
Everybody thinks the worst. What does presence mean, Richard? They have to be around.
Yeah.
Well, I think it's more like what type of presence do they have in a room? I mean, people are going to be looking at you to follow the plan. So are you a wallflower? Do you just kind of sit there? Or are you a bully? You don't want either of those, right? You want someone that has presence and people kind of respect, what they have to say. I don't know. That's what I meant by presence.
Yeah, and transparency. I think we discussed that. You have to be completely transparent.
Yeah.
There's no hidden things going on when you're the trustee. I think we are close. Let's say
there was one code we didn't talk about, Pete. So the reason this is in here, I think, because a lot of times this as we go through the codes, people get scared, like, oh my God, there's no way my daughter could do this, or there's no way my son could do this. All this work they got to do.
Okay, so how is the liability?
Yeah, what's the liability to this?
And so that's what standard of care means. Okay. Yeah. So the standard of care, the trustee shall administer the trust with reasonable care, skill, and caution under the circumstances then prevailing that a prudent person acting in like capacity would use in the conduct of an enterprise of like character with like aims for the purposes of the trust as determined by the trust instrument. In other words, you don't have to be an expert, but you definitely have to be prudent. What would a prudent person have done in this situation? Now, the key on the fiduciary duties is that in ordinary standard of care, if somebody sues you, they have to prove that you breached the duty of care to them. Hey, defective product, etc. In this area, fiduciary duty means somebody can accuse the trustee, whether it's a family member, trust corporation, a professional, a CPA, they can sue the trustee. The trustee has to show that they've met the duty of care. The burden of proof shifts. You're guilty until you're proven innocent.
Yeah.
Okay. It's a completely different kind of standard as a fiduciary.
But it's not. One thing you have to understand in this particular code is they don't, like, if you're sitting in front of a judge, they're not going to look at this in hindsight. They're not going to go, oh, well, you sold all the Apple stock at the wrong time. It obviously went up, in the subsequent months. That's not really what they're talking about. So you have to be prudent. You should be documenting. You should be, just careful about how you're handling this particular position.
Okay, we have a couple of minutes left, and we got a couple of questions.
Yeah, this is a big question we should address. How should family member trustees be paid? Can we talk a little bit about compensation?
Well, I think anybody who's going to be a trustee, whether or not they're family member or whomever, they should be paid. It's an administrative chore. It needs to be done in a business-like manner, and the person ought to be paid for it. How much they should be paid? We charge 1% of the assets annually. So maybe anywhere between 0.5% to 1% of the estate, or you could charge them, they could charge on an hourly basis. It just has to be fair and reasonable. But please state in your document that the trustee is going to, family member especially, that they're going to be paid a reasonable fee, and make sure that the other family members know that you have approved them to be paid, because people think that this is a position of honor and the person ought to do this absolutely for free. We all disagree with that. It's a job.
Yeah. So I mean, if you're going to throw a number out there, I mean, a lot of it has to do with the skills of the family member.
That too.
And the situation they're stepping into. How risky is it? How how many assets and different things they have to deal with. If you are charging annually, or they're charging if they're charging hourly, it's so important, back to that duty to account, that they really need to write down all their time and the description of the activity that they're charging for, just to protect themselves, to be honest, in case people.
Well, everybody wants to know why you are getting paid what you're getting paid.
Yeah, because you'd be surprised how quickly the hours add up. And it may come to others like, oh, they're benefiting from it and all this. But if you have that description of services and so forth that you've done, it makes, most of the time people go, oh, okay, yeah, I didn't realize it was that much work.
Okay. There's a lot of situations where the grantor is still alive, and then there's family fighting involved. And that's probably the worst of all possible situations.
Yeah. They had said a follow before. They had said, what happens if the grantor refuses to give necessary documents needed for the fiduciary to make the accounting?
Yeah, it's just horrible situation. It means that there's going to be a lot of legal expenses, and fighting amongst family members is just awful. If the hope is that that you can find somebody you can convince the grantor to be more reasonable. And and attorneys are not good counselors. Attorneys are good at knowing the law, and they don't get paid to counsel and to settle fights. So once you get to people get to the stage of hiring an attorney, the prospects don't look good.
Okay. I have another question. Sorry, I answered it and they didn't understand what I was saying, so I have to go back. Okay, so Pete,
we're 3 minutes over, so
I know. So what's going on? Okay, hang on, I'm gonna stop share. Next week is our final session. We're going to be going into some case studies, but essentially what's the point of the next session next week?
Okay, the next session is to give you a review, hopefully an overall kind of summation. Most times when you go to an estate planning workshop, it's a 1 hour workshop or 1 hour lecture. So we had 8 weeks of this. So what we're going to try to do is summarize the entire 8 weeks and go through some practical examples. If you have a question that we haven't addressed, please send us an email, either Trevor, myself, or Richard, and we'll try to get those questions answered in the last session. We've gone about 5 minutes over on this one. There's so much to say, we probably oversaid it. Thank you for sticking with us. And
thank you, Richard, for coming on. Appreciate it.
Absolutely. Thanks, guys.
And we'll see you next week. And have a great Memorial Day weekend. Stay safe.
Yes, don't think about this stuff.
Yeah. Okay.
Bye-bye.
Bye.
Bye-bye.